Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Haikal bin Shahdan, and for today I will be presenting a case review with the topic of restraint of trade, and the case is POLYGRAM records sendirian berhad and research and another. Moving on to the details of the case, the citation, as you can see here, is POLYGRAM records sendirian berhad and research and another in the year 1994, volume 3, Malay Law Journal, page 127. The court presiding over this case is High Court of Kuala Lumpur. The judge is Yang Arif Visu Sinadurai J. The date of judgment is on 5th of August 1994. So let's see the case summary first. The plaintiff was a recording company, POLYGRAM Records Sendirian Berhad, while the defendant is a rock group, which is a famous rock group in the 90s, The Search. So in 1984, the plaintiff had entered into a written agreement with the defendants, which we can call the first contract. And then the first contract was for a period of 2 years with an option for 2 further periods of 1 year each, exercisable at the discretion of the plaintiff. So the plaintiff can opt to prolong or extend the first contract. And then in 1985, a new contract, which is we can call the second contract, was entered between both parties, the plaintiff and the defendants, for the reason that there were some changes in the group's composition. There were changes in the members in the group. And then on the second contract, basically the second contract contained quite identical provisions with the first contract. However, there were some major modifications which the defendant had claimed to not, that was not brought to the defendant's attention by the plaintiff. The modification was that the option for the period of extension was extended to 2 additional periods of 24 months each. So instead of 12 months, it became 24 months each. And then in 1987, the defendant was dissatisfied with their existing arrangements with the plaintiff, with their recording company. And then the defendant made the recording of an album under a new company, Go Search. So basically, Go Search was a new company that was comprised of their own members of the rock group. So Go Search, they did the recordings while Pacific Music Corp Malaysia Sendirian Berhad did the distribution. So in 1988, the plaintiff claimed against the defendant for breach of contract, while the defendant had counterclaimed, among other things, both contracts to be declared voidable on the grounds of undue influence, assignment of the relevant copyright in all the songs recorded by the defendants with the plaintiff, and also a declaration that a clause in the second contract was void in restraint of trade. This is where we will be focusing on for today's presentation. So there were many legal issues in this case, but I've extracted the relevant legal issues in regards to the topic, which is restraint of trade. So the first legal issue is whether the covenant to provide exclusive recording rights during currency of contract is a restraint of trade. The second legal issue is whether the covenant to restrain a person from carrying on trade or profession in the post-contract period is a restraint of trade. And the last legal issue is whether both types of covenants are void. So the first legal issue is about the exclusive recording rights during the currency of the contract, when the contract was still in practice, when the contract was still valid. Next was whether the covenant to restrain a person after the contract was terminated or after the defendants were released from the contract. And lastly, we have to determine whether or not these two types of contracts, these two types of covenants are void. So we can see here the plaintiff's argument is, let me move that here. So you can see the plaintiff's argument is that they had argued for an injunction. They claimed for an injunction to restrain the first 5 defendants until further order until 11th June 1989 from number one, being free to enter into any recording contracts with any other recording company. Number two, entering into any distribution contracts with Pacific Music Corp, Malaysia Sdn Bhd, or any other company. And third, recording for any other recording company, including Go Search Sdn Bhd, except the plaintiff, which is themselves. And the plaintiff contend that in late 1987, the second contract was still in force, or even if it was not in force, the defendant was still bound by the terms of the first contract. And lastly, they argued that the defendant had committed a breach of contract by not complying with clause 6.5 of the second contract, which restrains the defendant for a period of 2 years after the end of the agreement from making records without the plaintiff's consent. So over here, this is their one of their contentions arguments in this issue. So we have to take a look at clause 6.5 first for us to understand what is this all about. So clause 6.5 here says the artist shall not, without the written consent of the company, render the artist's services in any part of the world as a singer or performer of musical works for the purposes of making records. During the continuance and in the case of the artist being released from the obligation or in the case of termination of the agreement. So in this clause, the plaintiff is telling us that the defendants were actually bounded by this clause where they cannot provide any form of services, including for the purpose of making records, without the written consent by the plaintiff, from the plaintiff, during the continuance of the agreement and also after post-contract, even if the defendants have been released from the contract or the contract had been terminated, they still cannot provide their services to record or making records with another different company without the written consent from the plaintiff. However, the defendant argued that they also counterclaimed for a declaration that the defendants ceased to be bound by any contract with the plaintiff. They refused to be bound by the contract. A declaration that clause 6.5 of the point 5 of the second agreement is void due to restraint of trade. And then the clause, because they argued that the clause prohibited the defendants from making any recordings even after the expiry of the contract for a period of 2 years, except with the written consent of the plaintiffs. So they believe this to be restraint of trade and therefore should be void. So the clause was a covenant in restraint of trade and should be void. So the Young Arif judge, Visu Sinadurai, held that in the clause 6.5 of the second agreement was a covenant in restraint of trade and therefore is void ab initio under section 28 of the Contracts Act 1950. So the only the clause is void from the beginning. The clause was not binding on the defendants at the time they began recording for Go Search or any other company subsequent to 11th June 1987. The plaintiff's claim was dismissed with cause, and the defendant's counterclaim was partially allowed by the court with no order as to cost. So we can see the ratio decidendi here is that number one, to answer the first legal issue, is that providing exclusive recording rights to the plaintiff during the currency of the contract is not a covenant in restraint of trade and is not rendered void under Section 28 of Contracts Act 1950. Because Section 28 here is only applicable in cases where a person is restrained from carrying on his trade or profession in the traditional sense of the doctrine. What is the traditional sense? It is the during the post-contract period and not during the currency of the contract. So we can only consider particular covenant to be in restraint of trade when it is made during the post-contract period after the contract had been terminated or after the defendants was released from their obligation from the contract. To answer the second legal issue, the court believed that, however, clause 6.5 here clearly is a prohibition of carrying on a trade in a post-contract period. So you can clearly, if you remember just now, the clause, it clearly shows us that it is prohibiting the defendants from carrying on a trade or profession in the post-contract period. The validity of such covenants are tested by the reasonableness test by the English courts. But it is different in Malaysia. The position in Malaysia is very different, whereby once the Malaysian courts take the view that a particular covenant is a restraint of trade, the courts have no other option. The courts have no discretion but to declare it to be void under Section 28 of the Contracts Act 1950. This is also subject to the three exceptions provided by the section, which is sale of goodwill, the dissolution of partnership, an agreement during the dissolution of partnership, and also during the continuance of a partnership. But if we take a look in this clause, the three exceptions in the section cannot be applied. This is very similar to the case of Wigglesworth and Wilson Anthony, which I will explain further during my case analysis later on. To answer the last legal issue in the judge's ratio decidendi, whether these types of covenants are void or not, the court believed that therefore only a covenant restraining trade in the post-contract period is void according to Section 28 of the Contracts Act 1950. Covenants regarding the provision of exclusive rights or services during the currency of the contract will not be considered as a restraint of trade. So moving on to the case analysis, right? I believe that this is a very significant case for us to see the application of the doctrine of restraint of trade in action, because the learned judge had provided us the guidelines, the necessary guidelines for us to determine and for us to distinguish or to make the distinction between the covenants, whether it is a restraint of trade or not. Because as I said before, the case is quite similar, very similar to the case of Wigglesworth and Wilson Anthony, year 1964, in the Malayan Law Journal, page 269, where it was a case regarding both of the plaintiff and defendants were advocates and solicitors working in Kota Baru. There was a clause in their agreement, clause 8, which says that the defendant shall not, for a period of 2 years after the termination of the agreement, to practice or carry on the business or profession of an advocate and solicitor within the radius of 5 miles from Kota Baru town without first obtaining the written consent from the plaintiff. So you can see the facts are quite similar here, whereby in clause 6.5 you can see that the plaintiff had also put a condition where the defendants have to have the written consent from the plaintiff if they wish to carry on or to provide services or to make records with a different company after the termination of the agreement or after they are released from their obligation in the contract. So the plaintiff in Wigglesworth here, he claimed for injunction to stop the defendant from carrying their trade, to restrain the defendant. But the court held that the interpretation of Section 28 of the Contracts Act 1950, whereby the question of whether the English common law test of reasonableness should be applicable or not, the judge believed that and I quote, he said, "I do not think English cases are applicable as the Contracts Ordinance 1950 in Malaysia is not based on the English law of contract. It is very different, uh, and and therefore the judge believes that we cannot use the test of reasonableness in the instances to determine whether or not a particular covenant is in restraint or trade or not. So here in Malaysia, once we identify that it is a restraint of trade, regardless, during the post-contract period, the court must declare it to be void ab initio. So I do agree with the decision of the learned judge due to three reasons. Number one, the judge had exercised his wisdom by analyzing and comparing the impugn clause with other similar clauses from relevant English cases. So the judge had provided us with a number of English cases where he took where he analyzed every single one of them and compared it with the current case. And also the judge had made a clear distinction between covenants restraining trade during the currency of the agreement and also during the post-contract period. So the learned judge, he has made that distinction, which further makes our job easier for us to understand which one is a covenant in restraint of trade and which one is not. And lastly, the judge has also construed and interpreted Section 28 of the Contracts Act 1950 accurately and accordingly by considering its application in Malaysia. So the learned judge had followed the the judgment held in Wigglesworth, and also that he had based his decisions and judgment accordingly to the applicability of Section 28 in Malaysia and how it should be applied as to according to the legislation, which is the Contracts Act 1950. So I believe that based on the reasons above, I do agree with the decision of the learned judge, and I believe that he has exercised his utmost wisdom in making the judgment. So I think we can conclude by saying that recording companies must review any covenant providing for exclusive services during the currency of the contract and covenants prohibiting services to other companies after the expiration of contract should not be incorporated into future contracts because it is a covenant in restraint of trade. Thank you. That is all from me.